The European Commission tried to do two things on the Americans, to basically say we're just going to agree on the word proportionate, which comes out of European law, but the only way to agree on that is that the Americans said we're going to have our own interpretation of proportionate, and that means that the surveillance that the US is doing, they will call proportionate, but it would actually not change in any substantial way. And as the Court of Justice already found that not to be proportionate, we're not changing the situation, we're just basically putting a tag, the word proportionality, on both sides of the Atlantic. The other issue is that we have a fundamental redress issue. We don't have any court or any place to go to in the US. They try to overcome that with a thing that they call a court, but it's actually an executive body, a part of the judiciary ministry. And the only thing you would get out of that is a rubber stamp answer. So you would always get exactly the same, so to say, judgment, no matter what your claim is. Someone put that quite elegantly to say you kind of know your judgment before you even filed your complaint. And that is probably not what the Court of Justice would accept as judicial redress under Article 47 of the Charter. So I think that is fundamentally on the two biggest issues. We may see another like half solution or not even half. And that hasn't worked twice before, so I wonder if this would work well another time. Last element that's interesting there is it's also going to be interesting for the judges of the Court of Justice, because if they kind of say that there is a fundamental violation of your fundamental rights in two cases, and the Commission comes back with more or less the same system, just with slight upgrades, it will be a matter for the judges to just feel taken seriously anymore. And that may also in itself have some dynamic at the Court of Justice to say, you know, if we tell you that that is invalid, we mean it, and we don't, you know, let you go just passing the same thing in a bit of a variation over and over again. I think for the privacy shield, what could have worked is if there would have been proper enforcement on the European side, not like 24/7, but like some highlight cases that would have probably built enough pressure that the Silicon Valley itself would have said, okay, we need to solve the issue. Because the Silicon Valley has a certain problem. If they want to sell their product globally, and actually their product comes along with American surveillance laws, it's very hard to sell, give us all your data globally, we're going to take care of it. But actually once your data goes into the US cloud, you have no rights whatsoever. That's a hard pitch as a company. So I think if there would have been enough enforcement, enough consequences, a lot of the Silicon Valley would have knocked in Washington and said, you know, guys, you really have to fix this because we're losing customers, we're losing revenue. And that could have actually get some movement in the US. Because I was talking to one representative in the US, and what was very open, they were very open about it and said, you know, we're not going to be voted for giving rights to foreigners. At best, my competitor is going to use that against me. So I need a good legal argument, like a good political argument why I should give rights to Europeans or anybody else abroad. And one argument could have been the economic argument. And that would have required to be a realistic threat, actual enforcement in Europe, and that's what we didn't have. So we basically just let him go and said, okay, you're not complying with EU law and we don't do anything about it. And learning effect is, okay, you get away with murder, so let's just continue. To be honest, I'm tired of this. I was already, after the first one, we didn't even want to do the second case because the second case, I was actually a defendant. I was sued by the Irish Data Protection Commissioner, so that way I even got into the case. Because I think the point of the Court of Justice is obvious. Now, the thing has shifted from a pure privacy question to a rule of law question. Can the Commission just basically overturn the Court of Justice by issuing the same thing over and over again and just saying, okay, it takes the Court of Justice 2 years to overturn, so let's just issue it over and over again with like some slight amendment so that we kind of keep our face somehow. And I think that is where this whole case is going to a purely political question or a rule of law question. And that gets me into the idea of really doing this another time around, because we have a problem in the European Union if the Court of Justice says, okay, this is invalid, and it's just not done because the Commission issues the same invalid thing over and over again. And I think that's more of a motivator right now and the reason to kind of bring this back, because that could be applied to anything else if that becomes the standard. And that is extremely problematic from a rule of law perspective.
Ein Angebot der Konrad-Adenauer-Stiftung.